my situation, I have 5 years of prior service at another agency and joined DOT about a year and a half ago. It's unclear in an accepted service position. It's unclear to
Mm.
me, my bosses, etc., whether I'm considered probationary or not. And HR doesn't seem to want to weigh in yet. So I just wasn't sure if you guys have like that explicitly defined for folks and could maybe circulate, because if it is less than 2 years, I know that would affect like almost half of my office.
All right. So normally, probation is 1 year the first time you become a federal employee. Normally,
Okay.
and there are exceptions. Uh, the other situation is normally if you become a supervisor, and the first year that you're a supervisor, you are also on probation. These are all normal. They do have exceptions for all kinds of crazy stuff. Accepted service is confusing. Uh, the only one that I'm aware of where you'd return to probationary status is if you were something referred to as Schedule A. So, and like you, we will also be talking to HR to see if we missed anything. In our experience, we've had this come up many times. But if you're Schedule A, then your probationary period would be 2 years. So if you're not Schedule A, and even if you're accepted service of some other kind of unique situation, you should absolutely be good to go. 5 years experience in the federal government, you should absolutely be fine. But we will check and we'll see if we're missing something that deals with accepted service. The
Hey,
basic,
Eugene,
yeah,
real
go ahead.
quick. Direct
Mhm.
hires. You may want to talk about that with the probationary period.
Yeah. That's the Schedule A, folks. That's the only one. That's the only direct hire that I'm aware of that has an additional time frame, which for them is 2 years. And anything else, we'll have to do some research on. If anyone should fall in some other peculiar, like accepted service, which I'll have to look at. So basically, the rule is if you were competitively hired, then you essentially should be good to go as long as you have 1 year of federal experience. If you weren't competitively hired, that that's where you get into the direct hire things that Jennifer just mentioned. And the one situation that we know specifically is Schedule A. There are others. They're really weird situations, and I've not heard anyone fall in, but we will do some checking to make sure that you guys are
Hey,
good to go.
Eugene,
Yeah,
when
yeah.
I do the new employee orientation, they do talk about direct hires. And if you are a direct hire, even if you have prior government experience, you are on probation for 1 year.
Yep, that's true.
And then, once
Yeah,
you
so
complete the 1 year,
so if you're not competitive, which a direct hire situation would put you in. And yeah, I would imagine that would be true. But I'm gonna look that up. I'm gonna make sure. Because after you, yeah, unfortunately, I think that is true.
Well, that's
Um,
helpful either way. I think
yeah,
there's a little confusion because the memo does specifically say 2 years accepted service positions. And so, yeah, if you guys can get some clarity on that. Again, I did look at the statute. It seems to say 1 year. So if that seems consistent with what you guys are saying, and that could just be, the new administration is mistaken on how it works. But I think it'd be helpful because this is something I'm hearing from a lot of different people. Um, that they're really concerned because we don't know how concerned to be, right? Like, do we need to consider other options, or, are we on the chopping block? Are we not? And so that would be really super helpful. I appreciate it.
absolutely, absolutely. So
Hey,
we'll look at we'll send you something on accepted service as well as direct hire. Um, uh,
Eugene,
that's
can
good.
you hear me?
yeah. I can hear you.
So I just joined, so I'm not. I'm sorry. You guys are mentioning a memo. What is this memo, and what is it referring to?
Yeah, so we're really talking about the executive orders and then the response to the executive orders. They come in the form of a memo from OMB, uh,
OPM.
PM.
OPM, rather. Yeah, OPM. And obviously, the thing that we're most concerned about is people. At the moment, we were talking about people who are subject to being on probationary status, and the fact that they've asked for this information and exactly what they're going to do it, we don't know. Our biggest fear is because if you're in probationary status, you are not subject to what's called due process, which basically means they have to jump through hoops to make sure that they didn't just arbitrarily remove you and didn't give you a fair chance. Unfortunately for probation, the courts have ruled that that's essentially an extension trial period of the hiring process. So they can just say, well, um, this isn't working out. But that's part of the questions that we will have for our lawyers. We still think, I think, just common sense would suggest that it there needs to be some level of responsibility. If I hired you and then all of a sudden I just decided for no reason whatsoever or for some political reason to remove you, that shouldn't be acceptable. There is a provision in the law that speaks to politically motivated actions that for people on probation, and exactly what that means is unclear to me. And like I said, we have a call in to our legal team, well, a lawyer group that we keep on retainer, and hopefully they'll give us some insight. And whatever they give me, we'll send back the answers. So far, my homework is find out about direct service for sure and direct hire for sure, as it relates to people who are on probation, and uh, we'll learn as much as we can about what the rules are for actually taking action for removal. Um, like I said, I know that there are some rules, some laws, and exactly how they play in practice, I'm really not sure. So someone asked, should your SF50 Block 24 change after 1 year? Uh, is Block 24 whether or not you're a probationary status? If the answer is that's what it is, then yeah, it should definitely change, and then you should get followed up and have them change it. And if you have an issue, get with us from the union and we'll make it happen. So if someone can read the chat stuff, I'm having all kinds of technical challenges. So if
Hey, Eugene, I can do that
yeah,
for you.
I'd appreciate that.
No worries.
All right.
Okay,
Anything
so
else? Anything else on probation?
there was a question here. Let me see. Let me find it here. And this was from Mara. She missed the first part of the meeting. She is probationary. She has 9 months. Does she have any protections if she gets axed against the recommendation of her supervisors?
That's what we're going to find out. I do know we had some good news in our research when we heard about this. We found there are some provisions, political is one of them, that that exist, but we want to talk to some lawyers to get more clarity in terms of how does that really play? How does that really, how does someone actually put that into practice? So I wish we had a better answer, but there are like 2 or 3 different things we know. If they try to remove you because of a discrimination, they can't do that. If they try to remove you because of there's a couple other peculiar provisions. Once again, since they were new to me, I want to check with the lawyers to make sure we know what we're talking about.
Again, Eugene, there's another question, and it's probationary period, and from Sarah that she's got 4 months of service, so she would appreciate any updates that can be shared.
Yeah, and that's my homework. I will share what we find out. There'll be no later than tomorrow. We'll send something out. Even if we don't talk to the Lord, we'll find out what we find on research. And I'll try to meet with our HR. Our HR folks are very, I'm in FMCSA. Our HR folks are very willing to chat about anything. So they're good people. So I can't imagine they'll lead us astray. And in the way that ensure that they don't lead us astray is we ask for legal references and that kind of stuff, interpretations, and we go from there. Someone asked, what does it mean if the agency or mode didn't sign the agreement? And this is kind of important, so I'm willing to repeat this for people who weren't here for the first part. So basically what's happened is three offices, PHMSA, FTA, and NHTSA, have made formal requests to have the collective bargaining agreements extended out to like 2029, 2030. And they hadn't signed them. So fortunately, some of the guys on our team from PHMSA, big, big, big salute to them. They found a reference in the statute that basically says if management doesn't, oh, you know what? I kept say again. So someone needs to move unless they're asking us. Yeah, someone. Okay. All right, but Bob, I don't want to talk about the specifics because I don't know who all are on the line. But trust me that we have something that has made us feel a lot more comfortable that we might get everybody under the wire. So, but since I'm not 100% sure who's on the line, for that particular answer, I just suffice to say we're working it and we're confident. But that is one of the things we'll be asking the lawyers. But I'm not comfortable sharing because I don't know who's all here. Elizabeth?
Yeah, thank you guys so much. I apologize if this already happened and I might have missed it, but do you guys have a separate session scheduled to kind of provide a high-level overview of the CBA changes that went into effect for those of us who maybe haven't had the chance to go through the entire document? So that's the first question. And then the second, just as a matter of like communication practice moving forward, I wonder if you all would be able to BCC all of our email addresses for any upcoming communication or invites. I did notice you guys have a combination of like work and personal email addresses, and we all could see each other's contact information in those invites. So just moving forward, I wonder if you guys might be able to BCC those just to ensure some privacy
No,
for,
I
for all of
appreciate
us.
that. I've attempted to do that in the past. There's a very complex set of steps you have to do for a meeting. It's not like you can just do it like if this was just an email, then yep, I would have done that. But I just need, I guess, some more training on how to make that work. We have attempted it in the past. It's failed miserably. But it's not an easy process. It's not like you can just put it all under BCC. Like if you go look at a meeting invite, you'll notice there's no such hidden mechanism. I looked it up on the internet, YouTube, and I found a way to do it. It was pretty complex. It didn't it didn't work for me. But yeah, we need to do a better job of that. I agree 100%.
Outlook has required and optional,
And optional. It doesn't,
but they don't hide any of the addresses.
but there is a way to do it, and I apologize. Like I said, I've tried it in the past. It failed miserably. But that doesn't mean I can't figure it out going forward. So I will make an effort to do that. Elizabeth, you go by
Hey,
Elizabeth?
Eugene,
Sure.
I pulled up the articles that we bargained on. So Elizabeth, you ready?
No, we're not going to do that right now. So
No. I'm not gonna go through them. I'm just gonna give the numbers.
But I think what she wants is for us to discuss what
Yeah.
changed or what they should be aware of. And I do
I'm
agree
happy.
with
I'm
Jeez.
happy to just look at the numbers, but I do think like a follow-on conversation for others
Yeah,
might be
yeah. And
helpful.
I think that's a great idea for every one of the modes. Every one of the modes is a little bit different. So that for just the OST folks, that would be a good thing to do. And we'll do the same thing for all of the other modes. I will say I'm just curious as to, at some point they will attack the CBAs. This is how it's supposed to work under the law. So if we're able to ensure that they are locked, then technically the only way it can become unlocked is if we at the union and the agency mutually agree to unlock it until the time period elapsed at the end. I can guarantee you we're not going to agree. So what they will probably do is an executive order that defies law, and then it'll have to go to the courts, and then we'll have to deal with that reality. So what does that mean? All right. So if the agency chooses to create a policy as a result of this executive order that violates the collective bargaining agreement, the collective bargaining agreement is supposed to take precedence. But if your boss is dictating to you that you need to do a certain thing, you have to do it. And then all we can do is then fight it and then get it corrected. But if your boss says thou shalt do something that is reasonable and not immoral or just absurd, and unfortunately you have to do it. It's not like, okay, everything is held in abeyance until a decision is made. You have to do it, otherwise they will get you on one of the two most easiest ways to find yourself unemployed. The two easiest ways to get unemployed, in my experience here in the federal government, is one, lying. They call it a lack of candor. Lawyers get all excited about terminology. And the second one is simply not showing up for where you're supposed to be. So if you don't show up and they tell you they want you in X amount of days, and you say, well, the collective bargaining agreement says I get at least 2 telework days, so I'm not coming in. And yeah, we'll be fighting for it. But in the meantime, you do have to come in. Any questions on that? All right. And this is the worst situation I've ever had to deal with. This is just so, I don't know what else to say. Somebody said this is a mess. Hey, Pamela Millbrook. I hadn't talked to her in a long time. Yeah, she's right. This is a freaking mess. But that's how that works. It'll go to court. We'll fight it through court. But in the meantime, you have to do what they tell you to do, as long as it's reasonable. Julia?
Hi,
Yeah.
yes, apologies if this was already gone over. I think I'm just so confused by it all, as I'm sure so many are. And if we don't have an answer to it, that's fine. I just thought I'd ask anyways. I was hired Schedule A, and I just was transferred to accepted service, like a week or so ago. And I know that the memo specifically states that employees in the competitive service with less than 1 year of service and in the accepted service with less than 2 years of service can be terminated. So do we know if that means service in that status, or service meaning years of employment?
Well, oh my God, what just happened here? Don't want to do that. I have to get back with that person. All right. So I want to make sure I say this right. So probationary periods don't just keep starting over and over and over again. So, but the accepted service, I don't know a lot about, because we haven't had to deal with it a lot. So we'll have to go back and answer that to get a very clear answer, because I'm afraid that they may tell me something bizarre. My original understanding was real clear. It's always just the first time. It doesn't like you have to keep happening over and over and over and over again. So if you join the federal government and you go through your probationary period the first year, then you leave the federal government, or you change jobs, you come to a new job, you're not on probation. You're good to go. Schedule A, yeah, you have the 2-year probation. I would assume just the one time. Now, if it turns out that that's something we'll have to research now. Gary, I don't know if you know better. We'll talk to HR. But if this is your first time Schedule A, for sure, you're on probation for a 2-year period. There's no doubt about that. If it's maybe the second time, that's a question I'm not aware of. I'm not 100% sure of. Because in that case you're not competing, and that's I don't know how that works. Do you have any idea about the second time around, Gary?
No, I sure don't. I
Yeah, so
don't know
we'll
much
find that
about
out.
Schedule A.
Yeah, but we'll find out about accepted service and the second time around, because everything else is just the first time. But that is unique enough to say, you know what, it could happen every time that you get picked up. So the person that asked the question, were you Schedule A previous to this?
Um, sort of. I had been with the feds, left the feds for DC government, came back to the feds under Schedule A. But typically the probationary period, yes, is 2 years, but then I think for some reason with mine, I also had to do the traditional probationary period of 1 year. Because I've been here 3 years and just got switched over to competitive service, which is why I'm not understanding the memo that came out and if it applies to
Oh,
me.
wow. All right. So now you really confused me. So
Hello.
did you complete the 2-year period already?
Yeah, yep.
All right, so you
Mhm.
completed
Thank
the
you.
2-year and then you went competitive after that. Is that right?
No, and
No?
then
No?
I think I'm still in accepted for a
Okay.
year.
Yeah, there's no reason why you would have to do it for 3 years. That's crazy.
I was
So
on OPM site today because I had a question from a pathways person about
okay.
this. And according to OPM, that you can, if you get converted to competitive, the time served and accepted can be applied against your probationary period for
So
the
that makes it
competitive.
even shorter than 3 years.
Yep.
Right.
So if you had
that
3 years of accepted, you should be non-probationary if they converted you to a competitive series.
Okay,
that
thank
makes
you.
perfect sense. And really, really appreciate that, Clint. That was awesome. All right. Any other questions? I was hired through a pathway program. I'm a 10-year role based off of my SF-80. I've been with DOT federal government for 3 years. What does this mean for me? Pathways, but you're competitive and permanent tenure. Yeah, we would really need to see your SF-50. Um, yeah, yeah.
Eugene, what is the implication of F for the FTA of not signing the extension for CBA agreement?
Well, it would mean that the old agreement stays in place, and that normally when the window opens for renegotiation, the agency would then reopen it. And so, which would be sometime in the next 6, 7 months or something, depending on the actual window that's been set up. But what we're hoping for, you said FTA?
Yes.
Okay. Yeah, we're hoping for FTA that we have a surprise for them. There's a special provision in the law that we hope to put into place, but I don't want to discuss it here because I don't know who all is listening. Okay.
Okay, thank you.
You're welcome.
Hey, Eugene,
Yeah.
you've got a question here, and this came from Keith.
Okay.
Protections for remote work. It seems like the memos tend to intertwine remote and telework, almost like the creator doesn't fully understand the difference.
Yeah, we've been complaining about that from day one. So you hit the nail on the head. We're flustered with that, but the latest thing that they sent out was, as of yesterday, was probably the scariest of them all. And they just basically said everybody's coming back into the office. Um, and they're supposed to come up with a plan by the end of the day. By law, they're supposed to, any policy or plan that changes the conditions of employment. Gary's probably gonna correct me and say, well,
Those conditions of employment, you're right.
okay. Conditions, if it changes the conditions of employment, then we get to bargain it and we get to engage, which would mean there'd be a little bit more time before someone would have to before they'd actually be able to issue an actual memo. But that's just going to delay the inevitable. And the reason is, as you all know, remote work as well as telework, neither of which are a right. They are a privilege that apparently the current administration is trying to take away from us. So yeah, we'll of course keep you posted as we find out what it is that they're actually going to do to us with regard to coming into the office. I know there'll be a lot of people who won't be able to come in. One of the things about bargaining for this, and the reason it's important, is because we know that pre-pandemic there was a lack of space. So a lot of the things that they're wanting to do, we're going to argue you can't do because you don't have the space, you don't have the parking, you don't have the transit capacity, you don't have the outside parking, not let alone the parking in the underground in our facility. Anybody who has a reasonable accommodation will be essentially exempt. So if you have a reasonable accommodation in place, the rules for the reasonable accommodation will drive your on-duty work requirements and that kind of thing. So if you think a reasonable accommodation is something that might fit your situation, give us a call and then we'll talk it through, and then we'll help you put together something so that you can present your case. The provisions, at least for the original emails that went out, said we're going to do everything by law, which would mean they have to bargain. We're going to allow some exceptions, which means they can't be just ridiculously evil. And there was a third one. What was it? Somebody help me, Gary. Gary, Mike, what was the third thing? There was a third provision. Yeah. I can't remember.
I don't remember off the top of my head.
But bottom line is that there's some flexibility that's going to be allowed, even though they're dictating right now. They want everybody.
There was a statement that the agency had with supervisor, but it was written, kind of in the thing of medical exception, accommodation, or they made it seem like an extreme exception granted by the agency head.
Yeah, that was one other thing I can't remember, but anyway, those are the main ones that if you have a reasonable accommodation, or if the agency deems that it's just not practicable, that's what it does.
Yeah.
So they use the term practicable. So practicable to me means, well, where are you going to put them? We don't have enough seats. How are you going to accommodate all these people breathing down each other's neck?
Yeah, I just pulled it out there, Eugene. It's unless excused due to disability, qualifying medical condition, or other compelling reason certified by agency head and the employee's supervisor.
Okay, so they're limiting that one, but in the previous one, they also added the term practicable.
Yeah.
Which opens the door.
Eugene, Selena's had her hand up for a while.
Hey, Selena.
Hey, Eugene. Good morning to everyone. Good afternoon. So, someone put a memo in the chat, and I looked the memo up, and there's a specific paragraph where they're talking about federal employees to return to work, and except for those who are covered by bargaining agreement. What does that really mean? And I can read exactly what they're saying.
Read it again.
So what they're saying in a memo Wednesday night, acting OPM Director Charles Ezel instructed agency 2 by 5 p.m. Friday to revise their agency-wide telework policy to reflect that employees are expected to work full-time at their respective duty stations. It allows for exemptions in the case of an employee disability, other qualifying medical condition, or other compelling reason certified by the agency head and the employee supervisor. But it goes on to say that except for those, let me find that part. It says ultimately employees will have 30 days or late February to fully comply with the order, with notable exceptions for the aforementioned exempt employees and for employees covered by the collective bargaining agreements with provisions governing telework. So
Okay.
I'm
Yeah,
mostly interested in that part.
yeah, so that's what we were talking about earlier, that the collective bargaining agreement, depending on exactly what it says, if it's definitive or a minimum number of days, which is a hard thing to do. We generally talk in terms of what normal is, and then they have to defend it. So unless the collective bargaining agreement disallows them to do what they want to do, then they can do what they want to do. So we have 5 different collective bargaining agreements. And so for each one of the offices, that's obviously our homework. We'll go look at that, and we will also send that out. Cynthia talked about FAQs. That will definitely be one of the FAQs we will share, and that is FAQs relating to the bargaining agreement um, uh, on remote work and telework.
Hello?
Yeah.
I think
Can you hear me?
also-
Yeah.
Yes.
Oh,
think-
okay. I'm sorry. I
Oh,
had
it's
to
all
keep, I had a problem with my mic and I came out and came back in.
Okay.
What we could do, Eugene, and I could get started on this, maybe put together frequently asked questions. We have a lot of questions here, but there's some questions that we know that employees, members, and the large bargaining unit may be interested in knowing. Another thing, members need to sign up for alerts at AFG National. As a member, you can sign up. You'll get these notifications. Please use your personal email address. AFG is doing a lot to fight for us. So I do advise, we're in a very challenging situation. So the more you know, the more information that you have at your disposal, and also know that the local is working for you strongly. So, but we need to all be on the same page, and information that you get from the local needs to be kind of like standardized. That's why I mentioned the FAQs. And I don't mind getting started on that, Eugene, and then across the other modes, other VPs and
Yeah, so
union
I
reps
love
can chime
I
in.
love that I love that idea, and to the extent that we can come up with sanitized information for
Oh,
each
yeah,
of the
yeah, we have
modes,
to
we
do
can
that.
we
I would
can
suggest having it sent to, personal email, not use government,
well we
government
can do that,
resources.
but I'd also suggest, like I said, if it's sanitized, we can put the
Okay.
information on our webpage. Make sure
Eugene?
everybody
Yeah,
knows.
I mean, whatever you want to do.
Yeah, Jennifer.
I'm going to say this name wrong. Al Khatib has a question.
Okay, Al.
Yes, good afternoon. Just a quick question about, this was raised, but not this particular element of it. This is related to the reasonable accommodation. It notes that it would be required to be certified by the agency head in addition to the
Yep.
supervisor. How is that going to be interpreted? Is that part of the existing process in place already to receive a reasonable accommodation, and or is it going to create a new process by which the agency head will have to confirm? Thank you.
Wow, that's a great question. And you have the coolest voice I've ever heard. You should be on radio or something. But basically, the they acknowledge the reality that they have to go through the normal process. So whatever the policies are, whatever's in place, they have to go through that, and then they go through the reasonable accommodation. And what they're really saying is, when you finish your reasonable accommodation, your boss's boss wants to be sure that you didn't do something I didn't like. Even though they're not supposed to be in the process, there's no reason you can not make them in the process. They don't really get a decision in it. The decision is made consistent with the policy. So if the policy says HR makes the decision, for example, and they make the decision, this is saying the boss's boss says, show me what your decisions are. That's all that is. So technically it's not changing anything. What they're saying is, if you don't do what I'm telling you to do, you, sir, are going to pay the price. So that is what that's what that's all about. Does that make sense? And how do you pronounce your first name?
It's
How
Maha. Yes, thank you so much.
Oh, your first
Maha
name
is
is
my
Maha.
first name.
Oh, okay.
It
That was
is,
your
yeah,
last name. Okay.
it
So
is,
for yours
yeah.
is like backwards from everybody. Everyone else's last name first.
I'm not sure why I renamed
Yeah,
it, but
but
thank
that's
you.
cool.
Thanks so much.
That's cool. Yeah.
Because she's
All right.
external. She's not within
Yeah,
within
I
the
noticed that
systems.
too after I
Yeah.
said that. All right. Hey James, what you got for me? You're on mute. James Mowry. All right.
James, you're on mute. Unmute your mic.
All right, why he's
Sorry,
doing it?
I'm sorry. This is
Okay.
Jim Mowry.
There you go.
All
All
right.
right, I'm sorry. Okay, has a concrete, specific get back to the office date, calendar date, been handed down to us yet?
No. No.
Okay, the answer to that is no. All right, thank you. Now, one more
Yeah.
question. It would not be too soon for me to start drafting and to submit to the union a proposed reasonable accommodation type request, based on
Yeah.
my age
Yeah.
and some medical. I
It
can go
is-
ahead. I
it
can
is
go ahead and do
timely.
that.
100%. Everyone on this call who has any type of issues, where they feel that they should have an exception or of some sort, let us know, whether it's an official reasonable accommodation or what I'm going to call a hardship. Reasonable accommodation means it affects you personally, and a hardship could potentially affect people around you, loved ones that you're obviously obligated to support for one reason or another. They don't carry as much weight as a reasonable accommodation, but they will at least listen.
Okay, so it's not too soon for me to start.
No, it's
drafting
not too
that.
soon. No.
Okay,
No,
now one more question. Okay, once a specific concrete get back to the office date has been handed down to us, we should get back to the office by that date, even though we have a pending request for, like for a reasonable accommodation. Is that correct?
you can make an arrangement for reasonable accommodation with whoever's in your organization.
Sorry, what did you just say? I mean,
so the answer is depends. So, and if you have a reasonable accommodation, especially if you've already been operating under reasonable accommodation, the expectation would not be that you come into the office. The expectation is that you clear it with your supervisor to say that here's what I'm doing.
Okay.
And then they make the call as to whether or not they feel like in the interim they need you to come into the office.
Okay.
But,
So the bottom line is to talk to the union and to my boss about that.
Absolutely.
I have to come in. Okay.
Yes.
I follow you.
Right.
Okay.
Once that
one more related question.
hardcore date comes out. Yeah.
Okay. One more related question. Have you heard even any gossip or grapevine news about when the concrete get back to the office calendar date might be?
I think they want it in 30 days.
It's probably within 30 days. Is that what you said?
That's what I'm afraid of.
Okay. Probably
the memo says to have plans in place within 30 days for return. Well, not plans in place, to have people back within 30 days is the targeted, but it says should, not shall.
Right.
Right. They have to, because you got to go through the process, whatever that process is. So yeah.
Okay.
So yeah, I think they'll be firing all guns to get it at 30 days.
Okay. So the concrete get back to the office date, it'll probably be February 20th or earlier. Is that correct?
I shudder to say that. I don't want that to become a self-fulfilling prophecy. So I would, I mean, Jim, we don't have a
Okay.
crystal ball.
Okay, I understand. Okay, when a concrete get back to the office calendar date is decided upon by our uppers, we
Somehow you just muted yourself somehow. I don't know if it was arbitrary or involuntary, but you just got muted, Jim. And I've had that happen once before too.
sorry, I'm sorry, Eugene. I don't know how I
Oh,
got
no
muted.
problem.
All right,
No
okay,
problem.
here's my question. Once a concrete get back to the office calendar date has been decided upon by the people in power, we will be notified of that calendar date by an email or by some means, correct?
Oh, absolutely.
Okay, all right. Okay. Just one other related question. As a guess, like a weather forecaster trying to guess the weather, what would you guess the probability, would be that the concrete get back to the office date will be like within the very next week or so?
Zero.
What?
Zero.
Okay, so it probably won't be quite that soon, within the next week or so.
It won't be next week.
Okay. Thank you, Eugene, for your
Yeah.
patience.
No problem.
What an irritating analytical mind I have. So I try to break things up.
You will always be one of my favorites. Absolutely, without a shadow of a doubt. I have never met someone as intellectually proficient as you. I mean, you're brilliant. You're absolutely brilliant as far as I'm concerned. So
Oh, good.
it's always a pleasure working with you, man.
All right. Let me
Heather, what
return
you got? You have a question for us?
let me return the compliment.
Yes. Can you hear me, please? Can you hear me?
I hear you perfectly.
Yes.
I hear you perfectly.
Oh, wonderful. Okay, great. Well, first of all, thank you for holding this and for answering our questions. I had a question that was related to some in the chat. I was hired as an ADL employee working in a region, had a
I
cube
don't know
there,
what
and then
what
I
is what
got
is what is
Got it already?
ADL?
Okay, I was gonna put you on speaker.
I'm
yeah,
sorry.
alternative duty location.
Oh, okay. Okay,
Oh, hold
gotcha,
on, let
gotcha,
me
gotcha,
I
gotcha.
need to fix my
So
audio here.
even though I even though I work at headquarters at DOT, I've had an office or space in a different city.
Okay.
So one of my questions is, have you heard anything about ADL? The second question is, I know that because I recently went remote, like about a month ago, and the deputy regional administrator was like, we don't have space. We don't have. He was so happy
right.
when I gave up
That's
my
right.
cube. They don't have. They let so many people go remote when the first
So Heather,
they
let me
opened it
ask you
up.
this: is your ADL at a site or is it at your home?
It's at a site, like
Yeah,
it's an office.
then that's what
So
they want. That's what they want.
okay,
You're
so
unaffected. You're
yeah,
not
so I wasn't
impacted at all.
sure, but
Nope,
I
not
know like
impacted at
other
all.
people might be in similar situations where there's just no space. Like what
Yeah,
happens
you're
when
100% covered. They even specify that in a very bizarre manner. But you're good. You're more than good. You will not be impacted by any of this.
okay. All right, because I know like our DRA was literally like, just bring in your lawn chair if they revoke them because there's
No.
no
If they
room.
tell you to do that, give us a call and we'll fix that. Okay.
No, I know. He was
Yeah,
give
give
joking,
us a
but
call, we'll
there's
fix that.
literally yeah. Okay. So it'll be a
Okay.
while is what I'm hearing from you.
For you, it won't be at all. You won't be affected. So
Because they would have, it seems like they would have to go through GSA and the lease new space and all that
No,
jazz.
they're not going to do that. That has to do
Okay.
with being practical and all that kind of stuff. So
Okay.
you had a
All right.
question?
Thank you.
Yes, we've had some new hires, and some of them are like in Florida, Alabama. There is no regional office there, I guess, with like for example, FTA. Will guidance be provided to those individuals as well?
There needs to be. I mean, I would expect that their home of record should still stand, even though we got this crazy memo that mind-boggling to me. But I think those people should be not affected. And I say that using common sense, but common sense is not all that common apparently. So we won't know, but my gut feeling is they will be unaffected.
Okay, thank you.
Sure. Hey, Frank.
Hey, yeah, so I had a quick question. So I don't know if there's any guidance on this yet or whatnot, but my situation is that I'm in the process of needing to needing to relocate to Florida. I'm a headquarters employee. I live near a federal office, but not FMCSA. It's a federal highway office. I heard people talking about like an alternate location. Is there a process in which, because I have, I would prefer, because of my family situation, need to live in Florida full time, but I would still be okay going in full time, but to a federal office. Is there any sort of guidance on that? I mean, this is a super specific situation that is special to me.
You'll still be assigned to the headquarters?
More than likely, yes, unless they wanted to, change that.
But I mean, your job, the nature of your job, your the people you report to will still be.
Yeah, the people I report to are still in headquarters.
Oh, okay. So, to your point, you're correct. We don't know the answer.
Okay.
In the past, 100% of the time, the answer would have been if the agency allowed you to do it, you would just go remote. You would just do it from home. That would be your duty station. That would
Yeah.
be it. But now, this is crazy stuff. This is crazy talk, man. Frank,
Yeah,
we will
just
ask we will ask the
yeah.
question about how they're going to treat any moves from here on out. I know how they used to, and I know what the rules are.
Was there anything in your remote work agreement? I know for FEMSA, they had a relocation in there if you were outside the commuting area, right? What they
Well,
had
he's
to cover.
currently at the headquarters. He's saying he's
Yeah,
going
so
to
I work in headquarters, but I work in headquarters full time, and my family, I live in Florida, so I on the weekends go home back to
Yeah.
Florida.
Oh, so you're on a telework.
Well, yeah, but I'm because of the nature of my job.
No,
I'm
I
in,
get it,
like,
but you're
Florida.
under a
Yeah,
telework appointment, not a remote work appointment.
correct. Yeah.
That,
Yeah, exactly.
that's
This
at
is
the
what,
discretion of leadership.
yeah,
Yeah.
and they may not feel like they have a lot of discretion, but we will ask the question, Frank, and that'll be part of my homework.
Okay, awesome. Yeah, because like I have no problem going to another office. I will report every day if they want me to, but I would prefer not to have to travel to back and forth to Florida on the weekends.
Yeah, that's crazy that you even attempting that. So
Yeah, I've been doing it for quite a while now, but gotta do what you gotta do.
all right, Suresh.
Uh, Similar question. I'm based out in New York, but I work out of DC. I was hired as a remote worker. I saw Clem post something there in the chat about working at the nearest federal building. I know here in New York we have quite a few federal buildings. How would that how would that work in terms for me to put something like that into play, or when would I get some type of guidance on that?
Yeah, so the agency will have to come up with what are acceptable sites, and that's news for us. That's news for them. They don't have a plan. I've only heard of like I'm in FMCSA. We have a sister organization, FHWA, and they're usually not far from a lot of our places. So if for whatever reason we can't accommodate somebody in FMCSA, they'll just sit with somebody in FHWA. But that was years and years ago. Uh, so we don't have an answer for that.
Okay.
I would hope they let you work from home and just say, yeah, well, we looked around, there wasn't anything. If they come back and ask later, we'll let you know. But that's up to that's up to management at that point. I just know what they used to do. I can't tell you what they're going to do when they themselves feel like it's restricted, like they don't have a
But
choice.
but in the event that I have to go to DC, what type of notice are we looking at in terms of turnaround time to?
Well, you're in New York right now,
Yeah.
and you're talking about potentially having to relocate.
Yeah, if I have to go to the office.
I don't think they'll do that to you, but I just don't think they'll do that. Let us know how things are playing out, but I just can't imagine them doing that. If they hired you and they said that your job could be remotely held, but you're uh fully remote capable, then that was a decision as part of the reason they hired you. And you're able to perform your duties from that location. And the fact that they have a subsequent thing to say, hey, put them in a government agency nearby, hopefully OST will say, we don't have any facilities nearby. Stay where you are, we're good. But if they make a big noise out of it, we'll let you know. And I would hope and I would expect that that's how it turns out. If it doesn't, let us know and we'll make sure that they give you, a fair transition. But yeah, I just can't imagine them doing that.
My concern, Eugene, is you look at what happened at Homeland Security.
What did happen? I don't know.
They pulled everybody back, and I have friends there. Their response from leadership is they don't care about these things. The order says everybody is in.
Yeah, well,
not enough space, not a problem.
Is
not
a
an
problem.
issue.
Just deal with just the reality. Huh?
Yeah.
Well, I've bragged about the leadership we have in the department. Majority more times than not, they're willing to stand up to absolute absurdities. That would be in my mind an absolute absurdity. Their agenda would be met. They'd have enough folks sitting in butts other places. So I can't imagine them doing that to you. But if so, let us know. We'll see what we can do to cushion it. Wow.
Okay.
That's all I can
Thank
say is
you.
wow. Yeah, I wish I had a better answer. Anyway, we're past the hour. I didn't want to spend any more time. I really appreciate you guys taking this time out with me. I will send out the recording, and if there's anybody who in the union who might benefit from this information, do so. And then I will also send up a follow up with the homework. Um, you'll notice that I had attached a budget. I'm going to ask you to look at that when you get a chance. And then the next time we meet, we'd like to vote on it. One of the things that we need to vote on, that I think is important, is because of this change in the way we do business, what kind of things do we need to do so that we're more independent and being able to provide support to you as union members. So I'm usually very, very, very positive and upbeat. These are punches to the gut. And but I feel like at the end of the day, this too shall pass. All right. That's all.